Now, Arik Air has been ordered by the Nigeria's Minister of Aviation to actually ground 8 aircraft. The airline's flights were abruptly halted through the Nigerian Airspace Management Agency, called NAMA's Supreme Court obtained ruling due to a litigation suit from billionaire businessman and airline creditor Arthur Eze over unpaid debts, while Arik Air has since obtained an ex parte order halting further execution. It argues that this decision disregards ongoing judicial processes at a federal high court, underscoring the complex legal battle involving substantial debts and court orders. This morning, Liborous Oshoma, lawyer, of course, in Nigeria, joins me to look at the implication, most especially the legal tussle and how it affects this particular airline. Liborous Oshoma, thank you so much for joining us.
Yeah, my pleasure. Thank you.
Now, Arik Air was given a notice of public auction of the planes by the court if it fails to pay its debt. And Arik managed to get a temporary court order stopping the auction process. But Nama still went on to ground it. Isn't that contempt of court?
Nama did not ground Arik Air. Let's get the point clearly. We should understand, this matter is a protracted matter. It started in 2016. Judgment was given, a federal high court gave judgment in 2016, I think June 2016. Arik Air applied, it was for a debt that the previous owner was owing, not AMCON. And AMCON had not paid that debt. They said they were only paying creditors. And so that judgment was obtained in 2016. Arik Air went to the Court of Appeal seeking for leave to appeal. And you know, for leave to appeal in itself does not mean that you have appealed. The court will first and foremost grant you leave to appeal. And the court said there were no arguable ground of appeal, and so they refused the leave to appeal. So that judgment stayed. Arik Air went to Supreme Court, and the Supreme Court also, par Justice Okoro GLC, in July, also dismissed that application for leave to appeal, upholding the judgment of the Federal High Court, Lagos. So the judgment creditor immediately registered that judgment at the Federal High Court in Abuja, and then got a garnishee order against Arik Air and order for forfeit and execution, and pasted those orders on the body of the aircraft named in the judgment. And you have aircraft registration number B737700 5N, MJF B7307 B7370, then another one 5N MJQ, sorry, and then dash 800Q400, and then 5N BKK. So all of these aircraft were attached as judgment debts. And it is a notorious fact to every lawyer that once a property is attached as a judgment debt, that property automatically becomes the property of the court. If these aircraft were vehicles, what they would have done, what the bailiff of the court would have done would have been to drag those properties to the court premises for auction. That is why you see a lot of vehicles in court premises. Those properties are properties that had been attached as judgment properties. So that is what happened to Arik Air. So what the Minister of Aviation simply did, Arik Air now went to get an order against that execution. And so what the Minister of Aviation simply did was to say, look, to forestall a situation where, a fait accompli will be foisted on our court, let parties go and resolve their matter. But the ones that writ of execution had been pasted on, there is nothing the Minister of Aviation would have done to stop those, to allow those planes to fly. That will mean the ministry also violating a court order. And you have a senior advocate for a minister, what should he have done in the circumstance to allow Arik to violate a court order, a Supreme Court order for that matter? So it wasn't that the ministry grounded Arik Air. What happened was a court judgment attached Arik Air airline. There's license. When you ground operation, that means you withdraw or suspend the license. Their license is still there. So if Arik Air, for example, enters into a partnership with another airline today, certainly they will fly. But for those airlines that judgment had been attached on, to allow them to fly consistently will mean, the ministry violating a court order. What if in the process, those properties are taken out of Nigeria? What becomes of our Supreme Court judgment? What becomes of the judgment creditor? So that's the issue. It is not that it wasn't the ministry or the aviation industry that grounded Arik Air. It was a court order that grounded Arik Air.
So basically, you just followed court orders. Now, while this continues to fly around, I'm talking about these legal implications to it back and forth. You talked about the need for a resolution of this matter because the ground or the fundamental reason for this is the fact that Arik Air is yet to pay a debt it owed someone who actually invested or sponsored its operations. What do you think in this particular case should be the best way to resolve this issue?
Yeah, from my record here, like I said, that judgment was delivered on the 8th day of March 2016 against Arik Air. And so I think this issue ought to have been resolved long ago. Parties ought to have sat down and resolve the matter and enter into terms for settlement. It's okay, we can't pay so and so amount, but we would pay X amount in full and final settlement of the judgment debt. But to say that you're going to continually drag this with court, when the courts, the Court of First Instance, Court of Appeal, and the Supreme Court had said there is no arguable ground of appeal. The appeal does not have merits. You can't even appeal because there's no merit in the appeal. You are owing somebody money. What are you appealing? And so the court has said, look, we can't even grant you leave to appeal. Go back and resolve your issue. So in this case, what should have happened would be just sit down with the other party and resolve the issue. So this is a 2016 matter. And so what they did was to enter the tarmac, court bailiff, entered the tarmac and pasted court processes on the body of Arik airplane. Should the aviation department or FAN or NEMA or whatever, the department responsible, should they still have allowed those planes to fly, despite pasting of court papers on them? The answer is no. That would be contempt of court. Do you know even the minister can be robbed of his privileged rank, senior advocate. They can drag him before privileges committee for allowing aiding a party to violate a court order where a writ of execution has been attached to that property. It is like a vessel where a writ of execution has been attached to a vessel, and then you still allow that vessel to escape from the shores of Nigeria.
Well, they could feign pretense and say that they actually didn't see those court orders being pasted on those assets.
There is no way court bailiff can come to the airport with police and then come and execute a court order at the airport, and you say you didn't see them. Who will you tell that in Nigeria that you didn't see them when they came? And that for a Supreme Court, no, we're not talking about just a high court order now. A Supreme Court had said there is no merit in the appeal, and so we refuse you leave. So Supreme Court had adjudicated on the matter. And then for a senior advocate of Nigeria, Minister of Aviation, you say you didn't see it? That's laughable. So let's keep the narrative straight. Because I've also interrogated both parties. And this is something that ought to have been resolved long ago, really. I've read this statement from Arik. I've also read statement from the Aviation Ministry. I've read the court judgment. I can send you a copy of the court order from the Supreme Court also. I've read all the document, and it is clear what the Aviation Ministry had done. It's in compliance with international best practice.
Okay, so you said since 2016 that this particular, legal tussle has been on, and one would have thought that the Supreme Court would have put this to bed a long time ago. Are there any reasons? We understand, the issues when it comes to litigations and court processes being duly followed and all that. But don't you think this would have needed an accelerated hearing so that this issue is finally put to bed and Arik Air knows his standings and what he needs to do? And of course, Arthur Eze, who actually is hoping to get his money back, would have, gotten it. I mean, having to fast track these court processes, don't you think that could have sufficed?
In fact, the Supreme Court did magic in this matter. Let me give you the timeline.
Okay.
On the 8th of March, judgment was delivered by the High Court of Lagos, entry judgment for the judgment creditor on the 8th of March 2016. Arik Air immediately appealed to the Court of Appeal. And on the 30th of September 2021, the Court of Appeal unanimously, a three-man panel, unanimously dismissed the appeal. And Arik Air again appealed to Supreme Court for leave to appeal the decision of the Court of Appeal on the 9th day of January 2024. So the matter came to Supreme Court on the 9th day of January 2024. And in July 2024, the Supreme Court delivered its ruling dismissing the application for leave to appeal. And immediately, the judgment creditor, which is the company now, Arthur Eze, registered that judgment of the High Court at the FCT High Court on the 26th of June 2024. Sorry, the Supreme Court dismissed it in June, and they registered the judgment on the 26th of June 2024. And then Justice Adebi of the Federal High Court in Abuja, sitting at Court 8, made an order after hearing motion M9785-2004, filed by Atlas Petroleum, attaching all the movable properties belonging to Arik Air. And those were the plane that I reeled out before. All of this while, when this matter were going on, Arik Air and their lawyers were a part of these processes. They were part of the processes. So a court now gave an order attaching the immovable properties. And then those documents were served on the Minister of Aviation. Minister of Aviation delayed for 2 weeks. This was done in June. This was done in June. Minister of Aviation delayed in June for 2 weeks, giving a window for Arik Air also to resolve its matter. When he couldn't delay further and they were threatening to drag the minister to the Privileges Committee for violating a court order, they had to allow the court, bailiff, and the police to come serve the paper and paste those orders on the aircraft so listed.
Okay.
So in that case, those aircraft can no longer fly because now they are property of the court to be auctioned to satisfy the judgment debt. You are owing me money. And then I come, I get a judgment against you, and I come, I say, okay, you have 4 vehicles. And the court says, attach those 4 vehicles. If you sell one and you are able to recover everything, then leave the rest. Okay. They will drag all the vehicles. They will drag, because you have to attach them. They will drag all of them, auction them, and then recover your money, and then leave the one that, the remaining one. That's basically what is happening here. So the Supreme Court had not done anything wrong. This case was timely. Parties had ample opportunity to defend themselves or even resolve the matter amicably. But they didn't opt. And AMCON also didn't do well here. AMCON ought to have looked at the issue. They said, well, because they are receiver manager, mind you, they are receiver manager, they only pay creditors, and that all of this debt, they didn't even look at it. Rather, they prefer to, drag the matter in court. So that's basically what has happened.
Okay, so let me just get your final thoughts on this. Now, Arik Air has come out to say that this came as a rude shock to it, looking at the grounding of its aircrafts. And this development has actually dashed the hopes of many travelers who had planned their movements with this particular airline. There have been disruptions in their movements. Now, for these passengers or these people, do you think they have the right to sue Arik Air for how these issues actually affected them?
Yes, Arik Air is trying to is trying to to appeal to sentiment of Nigerians. We're very religious, pity party people. They knew from day one, they knew what they were going into. They dragged this matter. They were in court with the other parties. And so this dashing hope, the judgment was not executed the day it was delivered. The judgment was delivered since an order was granted in June, and we're in July. So they had ample time to do whatever they needed to do. And thankfully, the ministry also have issued directive to fund, to assist Arik Air passengers, so that, the hardship caused by Arik Air negligence will not be, will not, weigh so heavily on the passengers. Like, to answer your question, yes, Arik Air were negligent. You can actually sue them. In fact, they should pay compensation to their customers. They should pay compensation to their customers. Do a refund to people that have booked your airline and not knowing that you are facing this kind of challenges. You also know, they know. And so, but did they disclose to these customers?
Okay.
No, they didn't disclose to them. So the customers have a right to refund and damages.
Okay, well, we've not really seen that happen so much in the Nigerian aviation sector, where we have flight disruptions and the airlines who have to bear the brunt. But maybe this could serve as deterrent in that manner. Liborous Oshoma.
Yeah, it is a rule. It is a rule. Quickly, it's a rule in the aviation industry that.
But in terms of implementation, we've not really seen that happen. It's just what I'm trying to.
No, but it's a rule. Once they delay your flight for more than 4 hours, you're entitled to.
You're entitled to it. Thanks for that clarification. Liborous Oshoma, of course, I'm a lawyer. Thank you so much for helping us understand this better.
My pleasure. Thank you.